then my lord, that will not lead to the efficiency of administration.
So what is being proposed is demarcation of 50-50.
Even 50-50, then you are competing.
So even it's not a compatibility. So even in that suggestion, the persons who are directly appointed will have a better chance because their entry level is 25%, and what is proposed is 50%. So double the number of.
That's why I'm saying that we don't want that benefit. Even though now I've become a direct recruit, I am saying for the purpose of merit, there should not be what is encouraged is that once that stream becomes homogeneous, then you compete with everybody in that. Correct. No, so I am arguing it on the basis of Indira Sani, which is 9
now being argued that once you enter a particular cadre, you lose your birthmark.
That's the sort of basic thing. What I'm saying by Indira Sani in 828, when they are saying that once you make this reservation even in promotion, then you are competing only with your own category. Namely, once you're supposing you do this 50-50, which is what is proposed in the first alternative, then the civil judges will be competing, the promotee civil judges will be competing only with the promotee civil judges, and not because your category of your quota of 50% is assured. You are then not competing with the direct recruits, which is something which is not desirable according to Indira Sani. Of course, the constitutional amendment related only to scheduled caste, scheduled tribe, that will not apply to us. That did away with this. But otherwise, the principle that has been laid down by 9 judges will still apply. Yeah. Then, my lord, at paragraph 834, whether reservations, the question number 8, 832, whether reservations are anti-meritarian.
That is answered in the negative.
Only because. So,
Narasani says that the reservations are not anti-meritarian.
Right. So, because there is a sort of a benefit in giving the benefit to the people who are traditionally disadvantaged. Just let me argue. Don't tell me to address. The third suggestion that the amicus has given, that 1 year for every 5 years. Now, the question that arises is, does Nath, because the first 2 judgments, my lord, Cortino, etc., don't permit it, but Nath, they argue, has kind of distinguished them and said that they deviated and distinguished and said that yes, this can be permitted so long as it is not from that stream. Now, I want to show your lordship, my lord, 2 paragraphs of Nath, which are in the amicus's written submissions. I don't need to take your lordship, my lord, to that. If your lordship has paragraphs 45 and 46 on page 35 of the amicus's note. And I'll explain my submission to your lordship before I read them. If the classification is based on a criterion which is directly relatable. Lord, this is on page 35 of his note is the quotation from Nath, and I am referring to 45 and 46. Thus, all that Roshan Lal. Yes. Thus, all that Roshan Lal's case lays down is that direct recruits and promotees lose their birthmarks on fusion into a common stream of service, and they cannot thereafter be treated differently by reference to the consideration that they were recruited from different sources. Their genetic blemishes disappear once they are integrated into a common class and cannot be revived so as to make equals unequals once again. Roshan Lal's case is thus no authority for the proposition that if direct recruits and promotees are integrated into one class, they cannot be classified for purposes of promotion on a basis other than the one that they were drawn from different sources. In the instant case, classification rests fairly and squarely on the consideration of educational qualifications. Graduates alone shall go into the higher post. No, I'm saying something a little different. Graduates alone shall go into the higher post, no matter whether they were appointed as assistant engineer directly or by promotion. Now, please mark this. Which means graduation is the classification that you are using. Those who are graduates will be given that benefit. The graduates can come from either of those 2 sources. They are not relatable only to one source. That's why I'm giving emphasis on this sentence. In our case, what the amicus suggestion is that experience as civil judges is the criterion that applies only to one of the two sources, and therefore it's directly relatable to the source. That is not permissible. Nath did not say that if the classification that you are using is directly relatable to the source, then that is also permissible. And that is why they were at pains to say graduates alone shall go into the higher post, no matter whether they were appointed as assistant engineers directly or by promotion. Namely, graduation could be a qualification which both those categories could have. So only those persons who had that graduation would be given the benefit. There was nothing wrong with that. But what he is proposing applies only to one category, that is the civil judges promotees, and not to the other category, that is, my lord, that the direct recruits. That is not permissible. Now, alternatively, my suggestion before your lordship is, supposing your lordship were not to agree with me on this argument of Nath not being applicable, then in which case, my lord, it should be given to those who have worked as civil judges, whether or not they are now in the direct recruitment category. Persons like me. I was a civil judge. I worked for several years as a civil judge. Today I have qualified for the direct recruitment exam. So now I'm a direct recruit. So if you are going to give that benefit on the basis that somebody who has that experience, who has worked,
That should also be given to you.
that should also be given to me, because the classification is based on this, that those who have that experience will turn out to be better judges. That is a benefit to them. Then that should be given to me as well, not only, my lord, to the promotees. That's my submission on that, my lord. Then, my lord, Justice Bagchi asked about Jagannath. I just want to quickly distinguish that. That was only for pay scale, not for the purpose of giving any benefit for promotion.
Here also, they are not asking for promotion, only their consideration for a particular post in a cadre.
In a sense, it's a promotion. Your lordship has seen the rule. There is a rule prescribed as to how you are going to be promoted to senior scale and how you are, it is merit cum seniority. That is Rule 27 and Rule 27A. In the cadre, there are separate posts for which a promotion criteria is laid down.
But loosely used, but not a promotion in the sense of understanding by service to student.
Now, secondly, in that case, it was, as my understanding is, my lord, again, not based on source. In this case, it is based purely on source. You are proposing a distinction between civil judges and direct recruits only on the basis of their experience as civil judges.
You are supposed to conclude by 1 o'clock because
Yes.
it's the answer to them.
So therefore, my lord, that was my last submission, that Jagannath, in any case, Jagannath is 3 judges, your lordship is sitting in 5, and my lord, it may not be laying down the correct law if it were to say that no, even if it is relates to source, etc., it can be done. According to me, it can't. That's my humble submission.
Everybody has to conclude by 1 o'clock. So otherwise, it will be unfair to them. We have granted them 1 day time.
I'm always the person who this is told to.
No. You should have timed it out because
I'm following the sequence.
what
The
is
discipline to the sequence.
we had granted them 1 day. They finished in 1 day.
I'm only arguing.
We should have finished in 1 day, but the timings which you are allowed it now.
My submission is in volume 2R4. 2R4, and I've had copies also.
Yes.
I have 3 broad submissions. 4 pages is what those submissions are. So I'll just immediately tell your lordships what they are. The first, my lords, your lordships have gone through the data points. You've seen the details, and I must say at the outset, we could not have had a fairer amicus. Mr. Bhatnagar is possibly the gold standard when it comes to that, in how fair he is in putting across submissions and putting across things which may not completely comport with the argument that he's going to make as well. So the amicus.
The data which he has given is based on the affidavits of the high courts.
Yes, of course. And I'm saying now that we have those, your lordships will recall that the first two orders which were passed in this matter, which are dated 17th September 25 and 7th October 25. I'm not reading it, but if your lordship were to see that, there were examples at that point which made one feel that, look, there is a complete imbalance in this. Now that some of the data has come, not all of it, but some of the data has come from the states, possibly not in the most ideal form, but they've put for last 5 years, they've shown with reference to principal district judges as well as district judges, etc. We find that that may not be entirely justified at a national level, clearly. There is,
Oh, yeah,
there are,
we can quite appreciate in different states,
correct,
there's a different position.
correct, very, very different positions. So now,
In Delhi,
yes,
the promoters are having a
Correct.
upper hand.
correct,
In
So-
so far as Calcutta is concerned,
correct,
there appears to be an equilibrium balance.
correct. So,
50-50.
so that,
In some states, it is totally dominated by the
correct, correct. So,
by the direct.
So
There's
I-
no uniformity.
So because there has been that shift that we have found now from the initial orders which led to this constitution and this question going on, I believe that one of the major, there are two premises as far as I'm concerned, page 1, I've set it out, two major premises that led to this very issue and the constitution bench looking at it. The first was that promotee judges are losing out on career progression. That may not be accurate. We have found that it could be both ways. So that,
It's a different situation in different states.
yes, it's a different situation. Exactly, which is why for a constitution bench to say that there is a underlying malaise, which is that promotee judges are losing out vis-a-vis direct recruit judges may not be an accurate premise to start with. I think that is accepted. Nobody is doubting that. Across the board, that is not.
There is also now another premise that in some states,
Yes,
that position exists.
Yeah.
And in some states,
it's the converse.
the direct recruits are at a disadvantage.
Correct, correct,
So
correct.
is it not more the reason that there has to be some uniform
No, so Manoj,
uniformity to
There
be
is-
adopted in all the states so that
if, and I adopt Mr. Bhushan's submission on this, if we are supposed to look at it purely as a service dispute, saying that, look, direct recruits versus promotees, maybe there is something to be said about that. But Manoj, as a constitution bench, when your lordships are looking at the judiciary in this country, I would beg to differ and say, please don't look at it as a service dispute.
no, we are not
Please
looking
look at
at, we are not, so please don't misunderstand it. We are not looking it as a service
Yes,
dispute.
but it
We-
becomes,
We are looking it with a larger objective of enhancing the efficiency of administration of justice in the entire country.
correct, correct. So if
That-
we have to look at it like that, let's consider what are the parameters being adopted for that purpose about efficiency of justice. Absolutely right. That's the only parameter, that's the only lens with which we must look at it. So if you're looking at efficiency of justice, is there any data that has come on record to suggest that promotee judges are better served at serving the ends of efficiency of justice as against direct recruit judges, or that direct recruit judges are better, or that a 1:1 ratio is necessary, which will help serve this? If we don't have any data, and to be honest, Manoj, I haven't found any being placed on record, that link doesn't exist. The link between the necessary ratios between direct recruits and promotees, the fact that one is better than the other, serving the ends of justice, I cannot find. In fact, unfortunately for me, what I can find is that the court that I practice in has 34 judges today, of whom not one is a promotee. So for me to come to that conclusion,
Court,
this court.
no promoting that.
So all 34 of your lordships.
That's begging the question.
No, so as far as I'm concerned, I find it frightfully efficient. But I don't know, would this picture have been different if there were 34 others? I can't answer that, Manoj. But I'm saying today,
Then
this court doesn't have a data point as far as they are
the
concerned.
5 of us sitting this side
Yes, Manoj.
are having experience of 9 high courts.
That's true. That's exactly, that in fact, reports is what,
Two chief justices who have come from the promotee. We've had two chief justices here who have come through the service route.
Yes.
so I'm saying,
And many judges, Justice Mudolkar,
Yes,
Justice Palkar,
there's no doubt. But I'm saying,
in this court.
are we to presume?
so we are not going we are not basically going on a dispute between a direct and promotee.
Correct.
We are only trying to find out what should be the best system in
Yeah.
order to enhance the efficiency of the administration of justice
Yes, so this is a continuing effort. It's always going to be a continuing effort based on our
Has been
lived
continuous.
experiences.
Yes. All India judges has been doing it
Correct,
continuously.
that's why it's been going on so long.
And it's a question of trial and errors.
Correct, so,
What this court found correct in 2002
yes,
was found to be required to be changed in 2010.
Yeah.
And after 15 years, this court again finds that it is.
that is true. That is true. And I mean, far be it for me to say, but whatever judgment comes from here, I'm sure there could be a revisiting based on
Yes, well, could be.
further experiences we have after 5 or 10 years. So my only suggestion is this, because the constitution of 5 judges in this continuing exercise, I don't believe is going to be common. I think it's a rarity. It's the first time it's happened here. So if your lordships were to lay down any principle, that principle, I think, should be based on 2 things. One, that we have enough data and we have some material on the basis of which we believe that there is some problem that we need to address. I am fighting to see where that problem is. What is the problem here right now, today?
Because you are
existing-
practicing only in this court.
No. I don't see that as a problem. I don't see that as a problem. I've gone on record. I've gone on record volubly to say that the lack of women in the Supreme Court on the bench is a problem. I see that as a problem. The lack of promotees, I'm not seeing this as a problem. I'm not seeing it there. I'm not seeing it here. I don't see it anywhere. So if there is, there has to be data and material to start with. That's point 1. Point 2, if we look at it as far as the law is concerned, those 3 judgments, I'm sorry, I think Mr. Bhatnagar didn't have enough time to place that fully before your lordship, but those initial 2, which are the ones which I've referred to at page 2 of my note, Mervyn Kutindo and Roshanlal Tandon, on facts, because I know, my lord, the Chief Justice had some misgiving about lawyers in this court only showing strands of paragraphs,
I
etc.
still hold that opinion.
Yes.
I still hold that opinion.
My lord, when we fight with tight timelines like this, when we're given 20 minutes, very difficult for us to show the full facts and everything. But I'm just trying to tell you what the context is of these 3 judgments. So,
in the matters which have been argued for days and days,
yes.
also we have, at least both of us have,
Correct. That is,
when we're sharing the bench, we have
That is-
did the same thing.
that is correct. I hope I will not be guilty of that. So, Mervyn Kutindo and
I
Roshanlal.
make an attempt to change the opinion of others because I have hardly now any
No.
days left to change us.
These impressions shouldn't rest with, it pains me every time I hear judges of this court, including judges who come from the bar saying, Supreme Court lawyers, you do this or that. I believe that we have to hold up the highest standards of advocacy in this country. And if we are falling short, then we must correct ourselves. And I do not want your lordships to leave with the impression that we have not placed the full facts of cases before you. Mervyn Kutindo and Roshanlal Tandon are very squarely on the point that is sought to be addressed here, which is effectively of creating a cadre within a cadre, which is the way Justice Bagchi had put it on the first day. It is precisely that. In Kutindo's case, in both those cases, both the constitution benches had framed 2 issues. And in both those cases, they answered one issue in favor of the petitioners and the other issue against the petitioners. And in both those cases, the issue they answered in favor of the petitioners is the one that I'm relying on now. I'm just breaking it down quickly because I want to reduce my time so that others can argue. In Mervyn Kutindo, it was dealing with principal appraisers within the customs department. It is, and this may answer one of the questions that my Lord Justice Surya also put, roster, did it really arise in the background of reservation of SC, STs, OBCs to try and fit them all with some level of fairness? I have found, in fact, the first office memorandum, just to give copies. This is a 1959 office memorandum of the government, which dealt with, in fact, Burmese civil servants were brought into our civil service, etc. So with reference to all of them, they dealt with and introduced the roster. Subsequently, it became a 40-point roster, and that's the one that is dealt with in Indra Soni, Sabarwal, etc. As the one that has to be adopted. And it's not in the context of 1516 reservations. It's in the context, effectively, if your lordships will see, there's one paragraph from that I just wanted to read to your lordships, which is that in page 5, the explanatory memorandum at the end, just see General Principle 6. General Principle 6 at page 5, your lordships have that?
Yes, related seniority.
A roster should be maintained based on the reservation for direct recruitment and promotion in the recruitment rules, where the reservation for each method is 50%, the roster will run as follows: 1 promotion, 2 direct recruitment, 3 promotion, 4 direct recruitment, and so on. Appointment should be made in accordance with the roster and seniority determined accordingly. Now, this is, I'm not troubling your lordships further with this, but this is where the genesis of this roster idea and its implementation started thereafter. Now, this question came up in Mervyn Cotindo on roster specifically, and not once again in the context of reservations. They specifically said that we believe that roster causes discrimination and therefore please don't have roster. Mervyn Cotindo's case, it's there in my note. Your lordships may just note that this was the argument that was taken. And at page 5, I'll just read this out. It's from that volume which is in the footnote, volume 5A. 5A is where the judgment is. At the bottom of page 5, referring to this very circular which I've handed to your lordships, they say this brings us back to the circular of 1959. And the main question in that connection is the meaning to be assigned to the words seniority determined accordingly in the explanation to principle 6 relating to relative seniority of direct recruits and promotees. As we read these words, the plain meaning is that seniority as between direct recruits and promotees should be determined in accordance with the roster, which has also been specified, namely 1 promotee followed by 1 direct recruit and so on. Where therefore recruitment to a cadre is from 2 sources, namely direct recruits and promotees, and rotational system is in force, seniority has to be fixed as provided in the explanation by alternately fixing a promotee and a direct recruit in the seniority list. We do not see any violation of the principle of equality of opportunity enshrined in Article 16 by following the rotational system of fixing seniority in the cadre, half of which consists of direct recruits and the other half of promotees. Now, my lords, if your lordships were to come to page 7, which is the next page. So they say that there are 2 levels that they're looking at, the appraisers and the principal appraisers. In appraisers, they say there is no problem with having this kind of a process system. The second issue which they consider is its application when you have 2 sources of recruitment, one from promotion, the other from direct recruitment, which is exactly what we're saying here. That once you come into this cadre of direct district judges, there's no question of looking at what they were previously. So page 7 brings in the middle of the paragraph dealing with the second issue. This brings us to the question of principal appraisers. We are of opinion that the petitioners have a legitimate grievance in this respect. The source of recruitment of principal appraisers is 1, namely from the grade of appraisers. Here, district judges. There is therefore no question of any quota being reserved from 2 sources in their cases. The rotational system cannot therefore apply when there is only 1 source of recruitment and not 2 sources of recruitment. In a case, therefore, where there is only 1 source of recruitment, the normal rule will apply, namely that a person promoted to a higher grade gets a seniority in that grade according to the date of promotion, subject always to his being found fit and being confirmed in the higher grade after the period of promotion is over. I'll just skip 2 lines. Insofar, therefore, as the respondent is doing what it calls restoration of seniority of direct recruits and appraisers grade when they are promoted to the principal appraisers grade, it is clearly denying equality of opportunity to appraisers, which is the only source of recruitment to the principal appraisers grade. There is only 1 source from which the principal appraisers are drawn, namely appraisers. The promotion being by selection and 5 years experience as the appraiser is the minimum qualification. This judgment, Mervyn Cotindo, is followed squarely by the Constitution Bench again in Roshan Lal Tandon. And in Roshan Lal Tandon, they were dealing with examiners within the railway board. And there, my lords, it was dealing with promotion from grade D to grade C of train examiners. And they said, once again, you form 1 single class. That is at page 16 of the same volume is the findings regarding that. There again, 2 issues framed. This issue decided effectively in our favor, in our argument's favor. Triloki Nath was dealing with the engineering service of Jammu and Kashmir. Much has been placed on the reliance there. And there they were dealing with assistant engineers and whether they had a degree or a diploma. As Mr. Bhushan rightly said, this could come from either of the sources. So it really makes no difference. Secondly, Triloki Nath was referred to in Davinder Singh, the 7 judges bench. Davinder Singh is a judgment which had 6 separate judgments in it. One was a dissenting judgment of Justice Trivedi. The other, including my Lord Justice Nath, Justice Gavai, all were in the majority. But we have to read each of those judgments to make sure that what was said about Triloki Nath was accepted by the others. Justice Chandrachud, writing for Justice Mishra as well, makes the comment that Triloki Nath is a law and good law and the leading law on the proposition that once you are in a cadre, if you have to look at special educational qualifications, that could be a factor for the purpose that you're seeking to achieve. In Tandon, it was the interlocunath, it was the question of examiners having a specific skill and a qualification that was required for the purposes of the work that they had to do in Jammu and Kashmir. The proposition that is formulated by Chief Justice Chandrachud is not one that is at all found in any of the other judgments. In fact, my Lord Justice Gavai follows N.M. Thomas, which says that Trilokinath does not apply. The paragraph is extracted where Trilokinath does not apply to the facts of that case is specifically said. So, to say that Davinder Singh, 7 judges bench, has followed and adopted Trilokinath is not a correct reading of ratios of judgments. That's not the way it goes. None of the other judgments agree with this on this proposition. Therefore, Davinder, if at all, is saying it as an obiter because it is not dealing with that issue. Davinder was looking at the Chinaya issue.
Davinder is basically dealing with sub-classification.
Sub-classification, that's all it was. So this has no rationale and no connection with that at all. If at all, it's obiter to that extent. In any event, I don't think Triloki does any violence as far as we are concerned. I have mentioned there are multiple options which are available, and your lordships have been responsible for ensuring that as far as any possible heartburn could be there. Because if as far as the promotees are concerned, there is heartburn, as recently as in your recent constitution bench, your lordships have already addressed that. If you see page 1 of my note, I've extracted that paragraph. Just let me read that out to you in this Rajneesh versus Deepa delivered last month. Your lordship say at para 159, and if I can read that, it's extracted at page 1 of my note. Insofar as the contention regarding the heartburn amongst the judicial officers in a situation where a junior gets promoted before the senior is concerned, in our view, the said contention is without any merit. The in-service candidates, though junior, will have to compete before being selected with the advocates as also their seniors, who also will be qualified, and only meritorious candidates would be selected and appointed. If a person is meritorious and on account of merit and merit alone gets selected directly as a district judge, there can be no question of heartburn for those who are not as meritorious as persons selected. Keeping that in mind, my lords, now consider the 4 measures that are in place as far as these promotees are concerned. The first is that there's a 25% quota LDC exam which is available, so they can participate and speed up the process. The second is the 40-point roster system. There's a page 3 of my note I've listed it. 40-point roster system. So the roster, if it's properly applied, if it's not properly applied, there's a problem. My suggestion, my lords, is after this judgment is done, please just supervise it, just like you've done in Prakash Singh with the police reforms, where all the states have to come and show that they are towing the line. In terms of Article 144 of the Constitution, let the states and the high courts come here and show what they're doing on the roster. If that's not being done, if LDC is not being conducted, they have to answer to it because there's a direction of this court. They have to follow it. The third is where you have reduced the minimum experience required for LDC from 10 to 7 years. Fourth, now in Rajneesh, you have opened it up for them to participate. So today, in the 50%, in the 25%, and in the 25%, they are available. They have all 3 avenues available to them. The direct recruits have only the 25%. They have all 3. All 100% is available to them. You could have a situation where all 100% are full of promotees. You could have that. It's possible. And, my lords, the question that I believe should be framed is the one at 3.2. When we look at what is the issue here, the question is not, do both promotees and direct recruits have equal opportunities to seniority in the district judge cadre? The question is the service of justice premised on the mode of recruitment of judges? It's, in my view, my lords, it's the second question that's the one that has to be looked at. Finally, my lord, just this one judgment that your lordships drew our attention to, which is there in the amicus, is on Jagannath. The distinction is that in Jagannath, they were a single cadre to start with. The cadre was then split up. They were split up as they were known as compositors, and the compositors had clerical work to do based on skills. And they said that the compositors were splitting into grade 1 and grade 2. And those who were put in grade 2 were put in grade 2 because they had lesser length of service. So those people objected, saying, when you're splitting us up, you can't do that because we have the same levels of same type of experience. They said, no, we're looking at skill sets and therefore this division is permissible. That's not the question that arises here. We didn't start as a common pool. We became a common pool, and once we are a common pool, you can't split us up. So it's the exact converse. I'm grateful, Manas. I'm most grateful.
Your Lordship's permission,
Yes.
I beg to appear for the direct recruit for the UP Judicial Services. And my IA number is 269748 of 2025. And my written submissions are in volume 2, R.3. R.3. And page number 6 of my lords has that, my lord. Honorable
Yes.
Chief Justice, my lord. My lord, I won't trouble too much because there are the two other people to follow. But I can only say this, Lord, I'm looking at the watch. My lord, I can only say this, that insofar as this side is concerned, the common consensus, and your lordships have heard it again and again, is that, my lord, the roster system is a good system. Whether your lordships finally accept it or not is another aspect. The second aspect which emerges, Lord, after hearing submissions of counsel from this side and that side is, sometimes it breaks. And as my Lord Justice Surya and Honorable Chief Justice said, when it breaks, what happens? Lord, your lordships have repeatedly said, if it becomes impractical, then you need not follow the roster system. Insofar as UP is concerned, my lord, the figures, my lord, in fact, if your lordship would see, for your lordship's convenience, at page 10, it's only for your lordship's convenience, my lord. We've taken the data from the amicus's brief, my lord. And your lordship would see 5.1. So Bhakti has it now.
Yes.
Lord, if your lordship would see serial numbers in that first table, 1 to 9, except for Rajasthan and Arunachal Pradesh, in every case, promotee judge, they are more, sufficiently more. My Lord Justice Chandurkar. Similarly, my Lord, 5.2, again, the ratio is higher. And at page 12 again, my lord, except for Bihar and Himachal, in fact, Himachal it's very close, my lord. Serial number 11, 4 and 3. Bihar, there is this huge dissonance, so to say, my lord. 86 and 5, 5 promotee, 8 direct recruits. But rest, it seems, the promotees have a healthy number. In fact, my lord, in Kerala, Justice Chandran would note that, and if I'm not wrong, please correct me, my lord. At the foot of that table at page 12, it says, my lord, para 7 of the affidavit, and this is from the affidavit, of the 48 principal district judges of the last 5 years, 30 are promotee. My lord has it, my lord. Page 12 at the foot of the page, my lord. 30 are promotees, my lord, these are high court judges, and 8 are direct recruits. So there is a healthy number in the constitutional court also, my lord. Of course, my lord, later on, as I think the position today is out of 42, it is now 10 directly recruited and 5 promotee judges. Now, insofar as Allahabad is concerned, my lord, and that's why I want my lords to see that judgment. When it breaks down, what happens, my lord? When your lordships passed the judgment in 2002, the AIJA judgment, my lord, your lordship said, go via the roster system. In Allahabad, my lord, till 2007, my lord, no corrective measures were taken. And in 2009, the rules were amended. With the result, my lord, in 2007 and 9, my lord, there were no vacancies filled and it broke down, my lord. Your lordships in Allahabad High Court versus State of UP, my lord, and para 12, if your lordship would see, not para 11 is a citation of my written submissions. It is important, my lord, to keep this judgment in mind because it covers a whole lot of precedents. And in paragraph 12, my lord, the court frames 2 questions. Page 15 is paragraph 30, my lord. I would just want to read that very quickly, my lord. With regard to the quota rule, page 15, my lord, para 30 of the judgment, of the 2018 judgment, which applied specifically to the Allahabad High Court. With regard to the quota rule, there is no doubt that there is mandatory requirement of the rules. Lord, my lord has it.
Yes.
The said requirement was, however, to be seen in peculiar fact situation. The issue of determination of vacancies was embroiled in continuous litigation. This was between 2002 and 2007. The quota rule could not be applied in the absence of determination of vacancies. The suitability test, though validly laid down, could not be held till 2008 for reasons already noted. No promotion could be given in the absence of suitability test. Not this was for the promotees, because under 2002 judgment, they had to have a suitability test. And then, my lord, your lordships go on to say the rule provided for seniority of the promotees to be fixed from the date of availability of vacancies, but such seniority could also not be given in the present fact situation. If the rule is applied, it will work serious prejudice to the promotees. Thus, the rules will have to be given a pragmatic interpretation as laid down by this court, not in an earlier judgment. It's a well-known direct recruits case. If it becomes impractical to act upon the rule fixing quota from two sources, it is no use insisting that the authority must be given effect to such rule. Every effort has to be made to respect a rule, but it's not feasible to enforce it. The rule has to be given practical interpretation. Thus, interference by the High Court with the seniority given to the promotees above the direct recruits without following the rotation principle cannot be sustained. Now, my lord, this judgment considered previous precedents, which is why, my lord, I'm not laboring that point. O.B. Kirk, Shrikant Tripathi, and Ashok Pal Singh. My lord, the sum, and in Randhir, my lord, in 2021, the court, my lord, sustained this principle. That is, you have to go by the roster system. If it breaks down, then you have to find a practical solution. Now, my lord, in sum and substance, therefore, my lord, as I started by saying, that the roster system is not perfect. Lord, it's something like democracy, we say, my lord. It's not the best system, but the others may be worse. One. Two, my lord, since your lordships have taken, and I don't want to repeat, my lord, three major steps, which is entry.
That has been argued at least
My
by
lord,
half a
why?
dozen.
No, correct. I'm sorry, my lord. I'll just conclude by one thing. My lord, why did the entry level experience come? And this is what I want my lord, the Chief Justice, to consider. My lord, your lordship knows that there is the NCMS, the National Court Management System. My lord, the committee called for empirical data, and your lordships notice that majority of the High Court said that there has to be some experience. The question was 1, 2, or 3 years. Some said 2 years because they said there is judicial training. Some said 3. Ultimately, your lordships decided one way or the other, 3 years. The other is about LDC quota, and then the Rajneesh, my lord. My lord, my respectful submission is, my lord, there has to be impact assessment. 1. 2, my lord, an observation that fell from one of my law lords, my lord, is diversity is an important aspect, my lord. You cannot just say that I must have only in.
Nobody is against diversity.
Yes, my lord.
On the contrary, the argument is that there has to be representation to all.
I'm deeply obliged. My lord, I'm deeply obliged. I'm only saying,
That
therefore,
inclusiveness.
no, I'm just trying to link it to my first submission, my lord. Therefore, if the system is not broken, it's my respectful submission, Lord, please continue with it. See how it plays out. Your initiatives, my lord, the Chief Justice, under your leadership, my lord, those 3 judgments are written. Please see how it works out. And as my lord, the saying goes, my lord, if it's not broken, let's not try and fix it. Because we
That
try
was
and fix something.
advanced by the learned Attorney General yesterday
Yes, my lord.
by replying to the validity argument which challenge the validity of the rules, the tribunal's rules, that the system should be permitted to work
Yes.
for some time, and then the court should decide about the validity of that.
Yes, sometimes, my lord, it is right. Even for law, we constantly say. My lord, the last thing that I want to say, sir, an observation which your lords made, my lord, let's have guidelines. My lord, the difficulty with guidelines is, and this is some amount of, any word from my lords, my lord, no Chief Justice is going to cross it, and should not, because there has to be judicial hierarchy, my lord. Once your lordships even makes an observation, lord, I don't think the Chief Justices will be able to cross that. So therefore, the danger in saying that we'll say guidelines with discretion, Lord, may not work. That's my respectful submission. Your lordship may consider.
I don't think Mr. Rakesh Dwivedi's argument. Thanks for doctoring.
Sorry, my lord.
You are adopting his argument, Mr. Dwivedi's arguments.
No, I'm not.
Hands off.
No, my lord. I am not going that far. I am only saying, my lord, in a judicial hierarchy, and correctly, my lord, if your lordship says something, They ought not to. It will bind them. They will not be able to use discretion. How your lordships are going to mold it is up to my lords.
Thank you.
Yes.
My lords, I appear for the direct recruiting judges from Maharashtra, state of Maharashtra, my lords. My submission is threefold, and quickly I'll do it in 12 minutes, my lords. Number one, what my lords have always encouraged is an equality of opportunity. When right from 2002, when my lords had introduced LDC, now Shetty Commission, at that point of time, the only way out was promotion. So they suggested one was weightage and another was LDC. What my lords did was came up with a clean scheme. Paragraph 27 to 30 in my humble submission, my lords, is a complete scheme. 29 may not be just taken independently. 27, 28, 29, and 30 is where your lordship first introduced LDC for the purposes of granting equal opportunity, a better opportunity to those who otherwise were not able to have an accelerated growth in their career progression. And therefore, in that context, my lords, what your lordship, I'll just read 3 lines, my lords, of paragraph 27. What my lords had indicated was, furthermore, there should also be an incentive amongst the relatively junior and other officers to improve and to compete with each other so as to excel and get quicker promotion. So my lords, number one, had taken this into consideration for the purposes of benefits of those junior officers who never had the occasion of otherwise moving forward in a fast track. These 3 lines, my lords, have repeatedly been followed by your lordships in 2022, 2025, and the recent in Rajneesh as well. Then, my lords, in paragraph 29, my lords created a link between these two. I'll just read again a few lines, my lords. As a result of the decision today, there will, in a way, be 3 ways of recruitment of higher judicial service. The quota of promotion, which we have prescribed, is 50% by following the principle, merit cum seniority, 25% strictly on merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where quota is in.
That is already.
Yes, my lord. So I'm connecting is only this, my lords, that the roster system your lordship had adopted, keeping in mind your lordship is also offering an alternative of LDC at that point of time, which today, my lords, with your lordship's recent judgment, has now additional district judges directly in Rajneesh. So my submission, my lords, is really, my lords have always been encouraging meritorious candidates who now have the option. Now, with the informed decision, somebody takes an option that either I'll continue as a service and go the promotion route, or I take an informed decision. My lords, I understand. I'm only saying is, my lords, 2 applicants, my lords, before lordship in this application, they had, considering this particular judgment of 2002, my lords, they had resigned as civil judges, practiced, and thereafter they had then given the exam for district judge. So there are situations, my lords, where people have actually made a conscious choice in terms of what is available and then move forward. So my lords, that is the first submission, my lords.
Legitimate expectation and is proper.
Lordship, please. My lords, as regards the Shetty report, my lords, what my learned actors had been relying on was the age group and the age gap. My submission, my lords, is the Shetty Commission data is today 2.5 decades old. And therefore, my lords may consider not relying upon that data for the purposes of laying down a policy for the next decade.
We are not relying on that. We are relying on the data which is applied by the learned.
I'm grateful, my lords. So in that basis, my lords, may I just submit for lordship's consideration? My lords, I've just compiled the data which was available on the record to my best of my capacity, my lords, in terms of what is the age difference, which is really happening today in terms of what it was.
Given on the basis of the affidavits of the.
My lords, I have taken that affidavits, my lords, only to indicate your lordships, and I put that in the annexure, that wherever the data is available, my lords, and it is part of my written submissions, out of 11 states where the data of 99 and the data of 25 is available, my lords, in 8 states, the age difference is actually reduced. So my only submission is, my lords, considering that your lordships had introduced LDC in 2002, and now in Rajneesh that your lordship has created another third possibility, the possibility of having the age difference being reduced in the long term is something which is quite would be there, my lords, and therefore lordship may consider having and continuing with this roster system for the purposes of this seniority. Also, my lords, there was one line where one word in terms of age changes, my lords. Again, a calculation which we have done, my lords, in terms of what after Rajneesh, what would happen. So far as civil judges are concerned, my lords, he would, at least by promotion, probably if we take 23 years as the age of entry as a civil judge, my lords, he will probably require 13 years to reach the age of district judge. But my lords, if the civil judge can become eventually district judge through the LDC route, he would have probably only a minimum of 10 years would be required. Similarly, my lords, an in-service civil judge.
The calculations have been given by DFR.
My lords, so I'm just saying, my lords, today the age gap is not only reduced in terms of whatever data is moved on from Shetty Commission today, whatever is available on record, my lords. The possibility of actually having some kind of a parity between these two groups is quite high, considering that your lordships have now, with this judgment in Rajneesh and in the judgment of Aja in 2025 and only to 2002, my lords have ensured that there are multiple options available to these in-service candidates as well. And therefore, to that extent, my lords, my submission would be that so far as roster system is concerned, that may be continued. Also, my lords, just one last word. The gradation list, which has been relied upon, my lords, your lordship has already seen. The gradation list may differ from year to year in a state, and it may not even be uniform between different states, my lords. And the reason would be in terms of that your lordship's directions and Mazhar Malik may not have been followed to the requirement in terms of what the period of and the requirement of recruitment policy is. If that is tend to hold, my lords, probably there is also a possibility that this entire roster system would not require to be changed, my lords. That is my limited assumption. Lordship. Great.
Yes.
Your Lordships, I appear in this IA number 258354, filed on behalf of the direct recruitees of the Rajasthan State Judicial Service. My Lord, I have five-fold submissions. In a nutshell, I know the time constraint and because Lordship has fixed five. My Lord, the first thing I'll submit with your Lordship is, my Lord, the amicus has raised a grievance that, my Lord, those people who come from the civil judge cadre, they don't reach up to the, my Lord, level of principal district judge. My Lord, my first submission is, my Lord, principal district judge is a posting. It's not a cadre, my Lord.
That's already argued.
No, this is what I'm saying, my Lord. Because, my Lord, now all high courts, my Lord, under Article 233, my Lord, they have got power of not only recruitment, but a posting also. So, my Lord, anybody who's posted as, my Lord, district judge, my Lord, that depends on not only on seniority, on acumen and other considerations which High Court feels, my Lord. My Lord, because all the district judges, including principal DJ, my Lord, they discharge the same judicial function. It is only administrative, my Lord, powers which are given to principal district judge in the maybe of, my Lord, the transfer of staff or, my Lord, giving particular cases. So, my Lord, what I'm saying, that this functional responsibility of principal, my Lord, district judge will not definitely confer him with any extra judicial power by which he can say that I have been deprived from this assignment. So, my Lord, my first submission would be that Lordship has to consider whether this grievance can be raised by people who have been inducted in service, knowing fully well that we have joined the ladder as a civil judge at a young age. And, my Lord, this has not been projected before this court that, my Lord, these people, first they become senior civil judge, they become ACJM, then they become CJM, then they become ADJ. My Lord, they are going in the ladder and ultimately, my Lord, they come to the cadre of district judge. So, my Lord, to say this by amicus that we have been deprived of this principal DJ, my Lord, with utmost, my Lord, humility at my command, I'll say, my Lord, this is absolutely unfounded. This is adding a new, my Lord, absolutely angle to the service jurisprudence was saying that for principal DJ, there has to be some quota or reservation. My Lord, my second submission would be, my Lord, that this quota rota system which has been introduced by virtue of judgment of this court, my Lord, that has been followed by most of the high courts. My Lord, I know about Rajasthan, I got rules also I have placed on record. My Lord, now there is a system of assigning senior to them that first three slot will go to the promotees. The fourth will go to direct duty. My Lord, this ensures that, my Lord, these promotees, they get their due and the direct duties do not march over these people, my Lord. My Lord, now third thing, the one, my Lord, fear which was alleged by Ms. Makhiza probably, my Lord, she said that those people by merit, now because now these, my Lord, people can come all three streams by judgment by lordships, my Lord. I'll not repeat that. So, my Lord, now once they come in limited competitive
Yeah, we have already, when she was arguing, we have already openly said what was in our mind with regard to our argument.
No, no, Lord.
Not,
What I'm saying, my Lord, one aspect has not been pointed out. My Lord, these limited competitive examination people who appear, civil judges, how their seniority will be reckoned. It was said that in the lower cadre, whatever seniority was there, their merit diminishes, my Lord. My Lord, there is a judgment of this court. My Lord, this is Dinesh Kumar Gupta versus High Court of Rajasthan, my Lord. My lord, this is 2020, volume 19, STC page 604. My lord, I had requested the court master to give it because I couldn't get the post to stop. This answers the, my lord, this particular fear of these people who come in the, my lord, counter to examination. Lord, I'll refer to the issue and then I'll give the answer to that which has been given by this court. My lord, there are issues which are at page 607. Please turn to page 607, my lord. Directly to the issue, my lord. At 607, my lord, Roman 4 is the issue. Lord, you have that. Whether the inter-se placement of candidates selected to the cadre of district judge in the state through limited competitive examination in the seniority list must be based on their merit in the state examination, or should it be based on their initial seniority in the erstwhile cadre? My lord, now please turn to the answer which has been given in this case, my lord. I'll refer to para 49 and 50, my lord. Lordship would find para 49, my lord, at page 666, 666, my lord. Please turn to my lord, para 49 and 50. Lord, para 49 starts. Lord, I see behind you, your lordship, my lord. Can I continue, my lord? I'll need, my lord, 10 minutes.
We can't be unfair to them also. We have given you half an hour more than what we had given to them.
Take it 2 minutes, my lord.
So,
Give me 5 minutes more, my lord.
because there are.
I think two and three are more left from our side.
Mr. Singh is also there.
Mr. Sanghi is there.
And I'm from Madhya Pradesh, my lord. I'll not take more than 10 minutes.
No, not 10 minutes. We'll
Five,
grant
sir.
all of you 5 minutes each.
All right, my lord. Yes, my lord.
So I will grant you 20 minutes and about half an hour to the Senate abacus.
Please, very well. I'll take less than that, but whatever.
Yes. If Mr. Dwivedi wants to add anything.
Let's take 2 minutes after the mic.
But follow the timelines.
Not after the break, my lord.
After at 2 o'clock,
Not
you 5 minutes.
Not.
Not. Yes, Mr. Gautam.
My lord, to allow the peers of, my lord, limited competitive examination candidates, my lord, this court has answered.
No, we are not on that. We are not going to go on to.
No, what I'm saying, my lord, that this issue that now recently your lordship have also decided, my lord, that the judgment Rajneesh, that these people will also have entry in direct recruitment quota. So, my lord, this law laid down by this court, my lord, takes care of now both the issues, that whatever seniority they had in the earlier cadre, that goes, and whatever merit they had in the competitive examination, they'll get their placement, my lord. So, my lord, my submission is that, my lord, to recognize the merit of these civil judges, there's enough care which has been taken by this court so far, my lord. And, my lord, ultimately, my lord, once they come in the cadre, my lord, then they cannot say that we should have a separate quota. My lord, that's my second submission. My lord, my third submission is, my lord, these people who come from, my lord, JMFC, my lord, as I have filed with my IA, my lord, in Rajasthan, there are 12, my lord, honorable judges who have been elevated to the bench. My lord, out of 12, 11 are from this JMFC. Only one honorable judge has come from other state. He was direct recruiting. Mr. Munal Lakshman probably. So, my lord, now to say this, that they have been sufferer because of this is also incorrect. My lord, I have also filed a list, my lord, where in last 10 years, there have been 287 postings as a principal district judge in Rajasthan. My lord, these people are 260, they are 227. Only 60 direct recruits have come. In last, my lord, 10, 12, 15 years rather, from 10 onwards. That list is there, my lord, I have filed it as an extra R2 in a volume, this thing. Now, so, my lord, to say this, that it has been a cause of heartburning or it has been not a cause of loss after joining as a civil judge, my lord, this is absolutely unfounded. My lord, my next submission is that the prayer which is being made by the amicus is about witness to be given. My lord, that has already been turned down by the, my lord, this court. And I'm not repeating that, my lord. My lord, last but
You are
not
not
the least.
repeating, you are saying that you are not repeating, but you are doing the same thing.
No, my lord. In one sentence, I completed.
Okay.
My lord, last but not the least. My lord, entire application which is filed by the other side, my lord, that's the aspirations.
Not by other side, by an amicus.
Amicus, my lord. Right now, because they are sitting on this side, I'm saying. My lord, they say aspirations of these people have been, my lord, affected, diluted, taken away. My lord, this is absolutely a wrong proposition which has been put forward. My lord, anybody who joins a judicial service, my lord, this court consistently held, they are not like a government service. The government servant, my lord, might have some aspirations in a cadre that I have to go there and here. My lord, anybody who joins as a magistrate or, my lord, to the top court of this court, my lord, it's only sacrifice, it's only, my lord, service to the society, and that is the object of any judicial officer. There are no frills attached. There are no, my lord, power attached to this job. It is only sacrifice, my lord. Either direct recruits come, they have a lucrative practice, they have worked at the bar for a very long time, and my lord, even the magistrate who joins, he also has a hope that in the ladder, I'll be rendering my service. So, my lord, after joining the service, if somebody takes a view that no, my chances are, my lord, taken away by such a system by the employer, my lord, that cannot be a basis to claim aspiration. My lord, I have to support that, my lord, why aspirations are limitless. My lord, I'll draw your lordship's attention to one application which has been filed in this court, my lord, by these all India, my lord, judges. Your lordship may have this IA. What are they claiming now? My lord, this IA, your lordship have this all India Judges Association, there's one IA filed. My lord, there they say now, not only reservation in quota for principal district judge, for high court also, there should be separate quota.
We are only considering the.
But what I'm saying, my lord,
considering the item filed by the learned amicus.
I know, my lord, but there's an IA which says that.
We are not considering that IA.
My lord, I hypothetically,
Anybody argued that IA?
No, my lord, I don't.
Why not
Tomorrow,
on it?
what I'm saying, my lord, these aspirations have no limit.
Yes, anyway, Mr. God, thank you, yes.
My lord, one last, my lord, last submission, my lord. My lord, ultimately, this court has time and again said that if you join a government job, you can get 2 promotions. That is the law, my lord, which has been developed right from Raghunath Prasad Singh. This is 1988 supplementary STC page 519. My lord, the judgment is a 2 paragraph, my lord, which is very relevant. Why this is necessary promotion, my lord? As I said, my lord, these people who join as civil judges, they at least get 4 promotions in their life, my lord. It's not that they are stagnating. It is only, my lord, comparing with these other people, my lord, that is causing a problem. So, lordship may have just look at this judgment. One paragraph I'll read, and lordship may have just look at this. Of course, my lord, it was a case of, my lord, police organization in Bihar. the person who came to this court, my lord, he did not have any chance because options were invited and he did not want that he should get an option and he should get, my lord, promotion. There was no promotion avenue. So, my lord, this court, my lord, in para 4, lordship, just 4 lines I'll read before lordship. My lord, para 4. Before we part with the appeal, we would like to take notice of another aspect. In course of hearing of the appeal, to a query made by the learned counsel for the appellant indicated the reason as to why the appellant was anxious to switch over to the general cadre. He relied upon 2 or 3 communications which are part of the record, where it has been indicated that there is no promotion opportunity available in the wireless organization. Reasonable promotional opportunities should be available in every wing of public service. That generates efficiency in service and fosters the appropriate attitude to grow for achieving excellence in service. In the absence of promotional aspects, like service is bound to degenerate and stagnation kills the desire to serve properly. We therefore direct the state of Bihar to provide at least 2 promotional. My lord, the judgment has been consistently followed. And as I, my lord, made a request.
Applicable here.
My lord, why I'm saying?
Yes, thank you. Yes, next, please.
Thank you, my lord. Obliged.
Please, Your Lordship. Lord, I am the second last batsman in the last over.
Yes.
So whatever I have to do is in just
Not second last, third last.
third last, my Lord. But I am in the last over in any case, my Lord. My Lord, I am appearing.
You already argued yesterday before a different combination.
Yes, but that was, my Lord, relating to the amendment, my Lord. I have the notification. Now I'm here to meet the submissions of the learned amicus, my Lord. My Lord, since only Your Lordships and Justice Chandran were there, I may inform, my Lord, in my written submission, I've made a mention of it, that while this matter is pending here, the state of Tamil Nadu has come out with a notification amending Rule 8 of the relevant rules, my Lord, on 7th of October. And what they've done is that they have actually vertically trifurcated the cadre of district judges by saying that there'll be different seniority lists. So, my Lord, that has been put to challenge. Your Lordships are going to examine. Your Lordships have issued notice on that. My Lord, my submission, my Lord, I've made a written submission. I'll not read it because it will take time. I don't have time for that, my Lord. So I'm just touching upon the points, and I have just 2 paragraphs to show from 2 judgments and 1 suggestion which I have, my Lord, as a counsel of Your Lordship's court, my Lord, not as appearing for a party, my Lord. My Lord, so there are 3 sources of recruitment, my Lord. Your Lordship is aware, my Lord, that once from different sources, recruitments are made and they are merged into one cadre, then, my Lord, the birthmark is lost. That is the well-settled position, my Lord. May I just read 1 paragraph in that regard, my Lord? This is from Bhatnagar's case. This is State of Punjab versus R.N. Bhatnagar, 1999, 2 SCC 330. At page 340, my Lord, I wish to read. May I read, my Lord?
Yes.
Requisition, yeah.
Huh? May I read slowly, my Lord?
Yes, you can.
Yes, my Lord. Yes. Yes. It says, it is on the contrary, it is a rule of recruitment from 2 different sources, namely in case of Professor cadre, 75% of the posts has to be filled by promotion, while 25% by direct recruitment. These 2 sources of recruitment permit departmental promotees and direct recruits from the open market to get absorbed in the cadre. They merely serve as 2 entry points for the cadre. Rule 9 deals with reservation of appointment for the post of to the post of professor and does not deal with reservation of post of professor for any special class or category of candidates. It is well settled that once recruitment is made from 2 sources, that is departmental promotees and direct recruitment from the open market, and once the candidates concerned enter into any cadre through entry point reserved for them, they get fused and blended into one single cadre and their birthmarks get obliterated. In this connection, we may usefully refer to the Constitution Bench judgment of this court, my Lord, in Triloki Nath, Hosa. Justice Chandurkar, as his Lordship was then was, speaking for the Constitution Bench, while dealing with the recruitment to a cadre from two sources, namely direct recruits and promotees, in the light of the earlier judgment of this court in Roshan Lal Tandon, made the following observations. The key words of the judgment are: the recruitment from both the sources to grade D were integrated into one class, and no discrimination could thereafter be made in favor of recruits from one source as against the recruits from the other source in the matter of promotion to grade C. Lord, page 341, I'm reading at the top. By this was meant that in the matter of promotional opportunities to grade C, no discrimination could be made between promotees and direct recruits by reference to the source.
That is already been argued by everyone.
Yes, my lord. So that is the position, settled position in law. In my lord, in B.S. Mathur, now what is going to happen if this
Again, all points have been argued, so we would appreciate that you say that you have some suggestion to be given.
Very well. I'll first give your lordship the suggestion. My lord, the real problem, which this submission has been advanced, the real problem is occurring because of the bunching which is taking place.
You also have the experience of 2 high courts.
My lord, that's what I'm saying, my lord. In case recruitments are made as per the roster year after year, as your lordships have already directed Malik Mazhar Sultan, then this problem will not arise because there would be proportionate representation for each class and they would be at the same level. What is happening is this bunching is taking place because, my lord, let's say for 5 years, recruitment is not made. Let's say, my lord, just to take an example, 2010, there are, let's say, 10 vacancies of direct recruits as per the roster. The recruitment does not take place till 2015 when this number is swelled to, let's say, 20 or 30. Now, what happens is that in 2015, when the recruitment is done, people who are eligible in 2015, that is those who are 35 plus in 2015, they occupy positions which were available in 2010 also. They may not be eligible in 2010. If supposing the examination were to be held in 2010, they may not be eligible. But when in 2015 they compete, they are competing for all the posts. My suggestion as a counsel is, my lord, that a distinction could be made that people who become, the eligibility should be determined according to the year in which the vacancy arises. If that is done, then a lot of this problem will be solved. Real problem, my lord, as the learned amicus argued, the problem is of age. All this problem about representation is arising because the age at which the direct recruits come is generally considered as lower when compared to the promotees coming into the cadre. Therefore, they retire, my lord, they fall by the side and the direct recruits continue. That is the real problem. So this could be met if the vacancy of a particular year, in respect of that, the eligibility is determined according to the age on the date of that particular year. So that is my suggestion, my lord. And your lordship, I will not take further time, my lord. B.S. Mathur, your lordships have already seen. And my lord, I only want to say that direct recruits, after all, this is, my lord, induction of fresh blood. That is the whole purpose. Otherwise, my lord, one can...
That's what 2002 judgment also says.
So, my lord, otherwise there is no need. One can do away with this cadre completely. So, it cannot be that they are put to such a disadvantage that this incentive is lost and good candidates don't appear in that examination. And with all the factors, my lord, your lordship's judgment in this year's judgment, my lord, 2025, the LDC age being reduced, in my very humble submission, my lord, your lordship should wait. And for example, in 13 states, my lord, in the country, there is no disparity, my lord. In Tamil Nadu particularly, my lord, I've given those figures, my lord. The position is that there is more than adequate representation for the promotee judges at the level of the principal district judges. They are more in number. That is because probably the recruitment took place, and recruitment of direct recruits, the rules came in 2007. The recruitments happened only 4 times from 2007 till now. That is the position. So in my humble submission, your lordships may not take any steps at present, my lord. Your lordship should allow the system to work and for it to be reviewed maybe 10 years later in case there is a need, which I don't think will arise because with the steps which have already been taken, this disparity will not be there. Of course, Mazhar Malik Sultan should be strictly implemented, my lord. If that happens, the problem will vanish, my lord. There would be no such grievance left. That's my submission.
Thank you. Yes, Atul.
Yes, I am representing direct recruits from the state of Madhya Pradesh, my lord, the higher judicial service officials. First of all, my lords, I'll quote certain statistics before going to the submissions, my lords. My submission would be that in the state of Madhya Pradesh, the situation is diametrically opposite to, my lords, what is the situation which has been quoted as an example from Maharashtra, Gujarat, Bombay or Gujarat, my lords, in the application moved by the amicus. Now, my lords, I'll just take my written submissions, my lords, are volume 2, R4. I have culled out the facts and figures from the counter affidavits of the various states, my lords. First, I'll point out the situation in Madhya Pradesh. Lords, before that, 2002, my lords, the 3-judge bench in this case directed that rota quota system must be adopted, my lord, by amending the rules suitably. The roster point system, RK Sabharwal. Till 2018, my lords, for 16 years, the rules were not amended. The seniority was determined on the basis of continuous officiation and date of joining, my lords. So 50% promotees, continuous officiation, and date of joining if the vacancy year was the same, my lord. It was 2018, that is after our batch joined, my lords, that 2018 for the first time roster point system has been introduced, my lords. Now, in our case, so what happened is something very startling, my lords. May just see WS2, which is page 59 of the written submissions. I have given certain dates. We are giving these figures, my lords, not just to highlight, my lord, that it is not a situation pan-India. All that a problem which may be existing in 2 or 3 states may not be telescope for the whole nation. Is my submission. 59, my lords, page volume 2, R4, 59. WS2, my lord, there is a table. That is before, my lords. There are 2 paginations. One is our pagination and the other is pagination of the written submissions. Now, my lords, what happened is 2017, I am representing the 13-14 officers from the 2017 batch, my lords. The advertisement for direct recruits was issued in March 2017, the vacancy advertisement. Both the 50% and 25% LDC was June 2017. The results were declared in August and September 2016. Ours were declared in October. The date of joining of the previous 2, despite our vacancy 3 months prior, my lords, the date of joining, because the rules were date of joining and continuous officiation, the date of joining of ours is 5-6 months after the 50% and the 25%. So what has happened is, my lords, by virtue of these rules, en bloc, all these direct recruits who were selected, en bloc in the gradation list, they have been pushed below these 75%, despite the fact, admittedly, when our vacancy was before. My lords, the other day, my learned senior, Mr. Patwali, also highlighted the same problem with respect to Delhi. So, my lords, why this has happened? This has happened because non-implementation of the rota quota system. If this has been implemented and efficiently, my lords, it would have been made effective, my lords, perhaps this problem would not have arisen. RK Sabharwal says, my lords, it is premised on the cadre strength on a running year basis.
But you are arguing before us. Now you want us to accept the seniority.
No, my lords, I'm not saying, I'm not pointing out. I am just pointing out, my lords, a state that it is not the situation pan-India. What has been projected, my lords, in the application, my lords, which has been referred to the constitution page. Today, what I'm trying to point out is...
We keep on repeating.
Yes,
claims of a particular high court or a set of officers, we are not going to consider.
Yes, ma'am. I'm not seeking that either, my lords, with due respect. It's just, my lords, that if the roster quota system is implemented, which is being done from 2000, the other thing...
Can be that rota and quota is one of the most acceptable principle to be followed.
I mean,
that's a general argument you can make.
In all fairness, I'll use the word, it's amongst all the other bad systems, it's the lesser bad. I would say.
You yourself be saying that in Madhya Pradesh High Court.
2018 it was introduced.
It has been introduced. Matter ends then.
Yes, now, my lord, matter doesn't end.
You are wanting us to apply it retrospectively to your matter.
I am coming to my next submission. Now, my lord, despite rota quota system being introduced in Madhya Pradesh, to every year, my lords, 50%, 25% examinations are happening, my lords. But for the direct recruit, my lords, 23, 24 and 25, we are at the end of 25. 3 years, my lords, this examination has not happened. So what is the inevitable outcome, my lords, is despite implementation of rota quota, inevitably it will break down. It will break down by virtue of a statutory provision, my lords, which has been introduced in Madhya Pradesh High Court rules, HJS rules, my lord, that where for 2 years the vacancy doesn't get filled up, it has to get surrendered. So, my lords, my submission is that this rota quota system has been introduced, and if it keeps working properly, efficiently on a year-to-year basis, this problem is not going to arise. All this concern, and this is because this rota quota system is not being implemented. That's my first submission. Now, my lords, without prejudice to this submission, without prejudice to this rota quota and all, my lords may just come to another table which I have presented, my lord, WS1, page 57, another table. On the basis of the facts and figures, first I'll refer to position in Madhya Pradesh. 41 years is the age of entry of direct recruits in the district judge cadre. 41 years, average. Page 57. WS1, it's a tabular chart, my lords.
Average.
Average 41 years in DJ cadre, direct recruit, 53 years in PDJ cadre, principal district judge cadre. Similarly, for promotees, it is 41 years as per the counter affidavit of the High Court, my lords. I have culled out that. 41 years in the DJ cadre for the promotees, the 25%, the 50%, and 55 years in the PDJ cadre, only 2 years gap. So, my lord, there is no prejudice as such, despite the fact that rota quota system has not been implemented. Now, my lords, I have given the, I'll not read all of them. I have given the figures of date of entry in Chhattisgarh, Jammu, Kashmir, Ladakh, Kerala, Punjab, Haryana on the basis of counter affidavits, the average age of entry, which has been evolved. Now, my lords, today, out of 52 district judges, the principal district judges, today, 52 or 51 principal district judges, 39, as per the counter affidavit, as on today, 39 are those who are from the promotee section, the civil judges. And only 12 are those who are from direct recruits. So, my lords, where is the ratio? The ratio rather goes in our favor. In fact, my submission is that the application should have been moved otherwise for addressing the concerns of the direct recruits, not for the civil judges, my lords. That's my submission. So, the ratio is 2.9:1, my lord, staggering almost 3 times of the promoters with the direct recruits. So, my lord, these were the facts and figures. Now, quickly, I have 2-3 submissions. I'll point out, my lords. There is
7 minutes or 2 more.
just yes, 3 more minutes.
Two more minutes.
Yes, please. My lords, one chart. My lords may just see in my written submission, that is volume 2, R4 would chart. I've just given a chart, my lords. After, my lords, now there are 2 dispensations. One is the pre-20th May dispensation and the other is post-20th May dispensation, my lords, which has arisen in view of my lord's judgment. I have given a chart, my lords, explaining the average time of progression of civil judge to entry into the district judge cadre, my lords. I'll not read that. And we have calculated it average on the basis of the counter affidavits, that if we take we consider merit, competency, diligence of the judicial officers, all the 4 channels now after 20th May, including the Rajneesh judge dispensation, my lords, 7 years. Within the age of 46, within the age of 40 years, my lords, even after 2 attempts, within the age of 40 years, the civil judges would be entering the TJ cadre, my lords. Earlier it was 41, 43, 44. Now, admittedly, within 40 years. So,
some lawyers have given a calculation that they would also enter at 35.
Yes, my lords, 35. As if we see the Rajneesh judgment, my lords, we have calculated it at 37. I mean, taking 2 attempts into consideration. If not 1 attempt, then 2 attempts into consideration. My lords, my next submission is the cure to problem of stagnation of civil judges, which has given rise to this application, my lords. The cure cannot be worse than the disease itself. The cure, my lords, has been already suggested in one of the 3 judges judgment of this honorable court in the AIGA case I have given with my compilation 2024 volume 9 volume 5 R9 page 102. In short, my lords, what has been proposed by this honorable court, accepting the SNJPC recommendations, 3 judgment, my lords, that assured career progression must be given, A, and second, there must be mechanism at the High Court level for compulsory writing of ACRs on an annual basis, reviewing, preparing, processing, and writing of the ACRs on an annual basis. If process of writing and finalization of ACRs is being done on an annual basis, my lords, as per the directions of this court, this stagnation is not going to arise because automatically the avenues of promotion will open up. My next submission, my lords, is that which is at page 28 of my written submission, that availability of uniform pay scale and equivalent promotional avenue for officers in the same cadre similarly situated is a guarantee protected by 14 read with 16(1) of the Constitution of India. Employees grouped in the same cadre, similar service condition, that is the district judge cadre, identical promotional avenues, common principal career progression shall apply, being a facet of equality in the matters of employment under state.
Yes, thank you.
Yes, Madam.
Thank you.
Well, just last submission.
No, you are already.
Well, 1 minute.
3 minutes, you are taken 5 more.
1 minute. 1 minute. My lords, Triloki Nath Kosa has been relied upon, my lords. Triloki Nath Kosa, Vide paras 34 and 35, allowed, my lords, induction of graduation as a requirement, eligibility requirement for promotion on the ground that it was in consonance with Article 335, that is efficiency in public administration. The Supreme Court accepted it as a facet of promoting efficiency. Likewise, my lords, here, it is not a public administration, it is just providing a progression opportunity. Malad, there is one more judgment, Muhammad Sujat Ali, Malad. In Muhammad Sujat Ali, what was held was that it is not necessary that you must provide educational qualification for promotion. What has to be seen is whether your requirement for reservation or preferential quota aligns with the nature of duties or not. Eventually, the nature of duty has to be seen, the nature of public office has to be seen, Muhammad Sujat Ali. And therefore, my lords, my submission, last submission, my lords, is that the criteria that they must have a short progression avenue or promotional avenue, my lords, clearly doesn't fit in the requirement of 16(1). Is my submission. Great. My written submissions are there, that they may be considered. There are 7-8 issues I have. Great.
Lordship, I'm representing a single applicant in this matter.
Yes.
And by necessary implication, other 16 members of the same batch. In the present case, the RG Delhi, Jharkhand High Court has almost perjured himself by stating in an affidavit, considering that the provisional promotion that have been given shall be considered as promotions. Now, what has happened in Jharkhand is that despite 10:1 ratio on affidavit stated by RG Jharkhand High Court, they have already promoted via the notification dated 17th October this year itself, and provided selection time scale as well as super time scale. Thereby, anything that this court holds, unless given retrospective effect too, will have direct bearing on the process. Firstly, the law which is already prevailing is not being followed. Roster is not.
We are not addressing the individual grievances.
Your Lordship, this is not an individual.
You address on the issue frame.
Your Lordship, I didn't address a collective grievance. The process of screening of the problems, screening of the complaints that are given against judges, there's no mechanism of screening of the problems that are the complaints, the bogus complaints that are usually.
We are not considering the individual case of an individual judicial officer as to whether there are any complaints or not. We are just the issue has been framed by the court. Address us on the issue.
Your Lordship, that has a bearing on
a
person's.
Yes. Yes.
No, Lord, may I just make a small request, Your Lordship? May an indulgence, Your Lordship. I just want to.
My submissions are on record. They may be considered.
That's not come on record. I'm not raising arguments. I'm just giving Your Lordship the statistics.
Use the mic, Mr. Allah.
His Lordship?
Use the mic.
There was people here, so I didn't. Lord, I'm not addressing arguments. I'm just giving your lordship statistics in case a quota is implemented, how the seniority will be disturbed. So lordship may just allow me to place that on record. While your lordship is writing the judgment, lordship may consider it. This is with respect to Haryana. May I just, if your lordship, may I just pass this on? I filed an IA. It's somehow not come on record. If your lordship could show me this indulgence, I'll just.
Yes.
Lordship may just have para 21. I'll just point out one small para.
Not arguing, you are only
No,
talking
no,
about-
not at all, Lord. I'm totally satisfied with whatever everybody has said. I'm not going to trouble your lordship on
We'll look into your statistics, huh?
just the statistics. That's all. Because nobody placed them on record. It's just para 20, page 21, Lord. Lordship will just see what's going to happen. This is Haryana. This is A2, page 21. Lord, up to 2030, even if there's a 25% quota your lordship grants them, nothing will change. But after 2031, lordship may just have the last para of there'll be a dramatic change. May I just read the last, at the bottom, the last para? DR number 68 to 76 appointed in 2014 will be junior to promotees number so-and-so promoted in 2016. And then this will continue like this. I'm just pointing out these facts to your lordship. So there'll be a complete churning of the seniors will become juniors. This will continue. If your lordship could ask the High Court to verify it, I'm putting it on record on the basis of what I have seen.
You are appearing for whom?
I'm appearing for one of the additional district judges, the direct recruits. And also, Lord, in Haryana, and in, over the last 10 years, only I think we have only about 6 direct recruits for the last 10 years.
The only last recruitment I had,
Yes, your lordship was.
nobody has done.
Nobody, there's been no recruitment. So this factor could also be taken into consideration. And then, your lordship, what happens is every recruitment is challenged again and again and again before this court.
11 years. Direct recruitment, last recruitment I have. Chairman of
No recruitment, Pillar. That's the difficulty. I just wanted to bring all these facts before your lordship. It would help your lordship in making up your mind one way or the other, because there are serious problems otherwise. Now, this candidate, may I just point out, Lord, the vacancy came in 2004. 3 years, she had to wait for her appointment. And in case this happens, she will retire as an ADJ. She will not even reach anywhere near being a district judge. What to talk of coming to the High Court? That's a pipe dream for her. But
yes,
I've given this, Your Lordship. I just don't want to say.
May I just pass on one page of data, my lord, only, or arguments. Regarding that age, my lord, which I mentioned that the average age of the civil judge is 28 years. So large number of candidates are appearing who are of a higher age. So this discloses the data of the age, my lord, which the various candidates have appeared at different ages. So large number of almost 40 to 50% are my lords, above 30 years of age. That's one of the reasons, my lords, for age gaps. And it's a matter of choice, my lord, when a candidate appears, for sometimes people take chances of various other.
Yes, ma'am. My lord, would your lordship just have my written submissions, because I want to place a couple of paragraphs. My lord, your lordships may kindly come to page 23. So at page 23, my lord, at para 29, after setting out the various views, the various, my lord, situations where promoting judges are more or district direct recruit judges are more, this is, my lord, my submission in substance, in spirit for your lordships to consider. It's just one para I wanted to read. If your lordships has it, I'll just read. Sorry, my lord? Yes, yes. The above shows, so above is the data that I put. shows that while in many states, mostly direct recruit district judges are occupying the post of principal district judge super time scale. In other states, the position is stated to be the reverse. Only in very few states, the promoted district judges and direct recruit judges are occupying these senior posts in almost equal numbers. Therefore, it is submitted that it is imperative to strike a balance between the two situations, whereby while incentivizing the appointment of direct recruits from the bar, the extremely valuable judicial experience of in-service promotee judges is not lost, and both promotee judges and direct recruit judges are equally provided an opportunity to progress to the post of principal district judges and beyond. So this is the spirit in which, my lord, I have made my submission. Now, my lord, so your lordships have seen, in fact, even from what my learned friends on both sides have said, I am, of course, as an amicus, is that, my lord, there are different situations in different states, but there is a problem that needs to be addressed by your lordships, is my submission before your lordships. Your lordships may not take it that promotees deserve something here or the direct recruits deserve something in another state. It's not a state-specific problem, it's a national issue on which, my lord, I respectfully submit that your lordships will take a view to address the problem itself. I have given some suggestions. There can be any other suggestions which may be correct also, my lord. These are my suggestions for your lordship's consideration. Now, my lord, one of these suggestions that has come from the other side and which is a valuable suggestion, in fact, my lord Justice Surya put it to me on the very first days, if the roster works perfectly fine year by year, etc., then a large amount of these issues can be sorted out, dealt with, etc. And the answer is yes, it can be. But, my lord, it will not fully deal, in fact, it will not deal with the age gap because the roster will not take into account the age gap. The roster will fully, my lord, perfectly. So far, unfortunately, the roster has not worked for 20 odd years, but let us assume for the sake of argument that Malik Mazhar is fully followed, roster is fully followed, every my lord, post is filled up annually, etc., perfectly filled up. The age issue will still not be gone into. And therefore, that is one of the points, one of the reasons which leads to bunching at the top. It is an important facet which will not, just by proper working of the roster should work properly, of course. And therefore, in some of my suggestions, my lord, if your lordships were to take that into account, that will require a bit of tweaking. That is my second submission before your lordships. The roster, my lord, will be working perfectly at the entry level, as I said, perfectly at the entry level. But, my lord, when it comes to financial upgradation, Shetty Commission uses the word financial upgradation. Promotion is a word that the rules mention, but it is actually in the nature of a financial upgradation to selection grade, super time scale, cadre being the same. That is where the bunching will happen because of age disparity. That is not the reason why I have given these suggestions for your lordship. Otherwise, my suggestion would also have been make the roster work properly and this sorts out the whole problem. So this is, my lord, my second suggestion.
That hardship which was being caused because of this age factor,
my lord,
that stands effectively addressed by the other constitutional bench. We took this.
Rajneesh, my lord?
The other constitutional bench judgment now.
My lord, that only deals with the issue of civil judges now being allowed to directly. Yes.
So they are able to now compete even for directly.
Correct.
Or if they are eligible for the 25% with enhancement of from 10% to 25%.
I'll answer that.
So they will have now accelerated promotional avenues.
Correct. So I'll straight away come to that issue because that's a very important point. What was said was, and it was also correctly said, that there are three avenues open. Firstly, my lord, from civil judge junior division to civil judge senior division, after 3 years, you have the option to take this limited competitive examination. So that gives you one opportunity to move upwards. Second opportunity to move upwards, my lords, is from civil judge junior division to district judge entry level by taking the limited competitive examination, which was there since 2002. And what my lords have just put to me is now there's a third way in which you can abandon the civil judge cadre altogether and join the direct recruit cadre. That's an option open to you. You know, the only difficulty with that, of course, it's open and people have their choices. Problem with that will be that there will still be 50% of the district judge cadre who will not be an LC, will not be part of LC. These are not dead wood people. These are people who've been promoted from step to step, passing suitability tests, etc., based on ACR and performance. So it is not as if these are people who don't deserve anything. So, these are highly deserving 50% people who may not have gone through or may not have cleared LCE examination or may have chosen not to take direct recruit examination, but that is 50% of the cadre today. So, that will always be the case. Whoever moves on to a higher, takes the LCE, etc., but still 50% will be these people. So that is a suggestion, for lordship's consideration, that one has to, so balancing will require consideration of this 50% of the cadre also. Now, my lord, next, let's examine one more issue. Let's look at the question of, my lord, selection to selection grade and super time scale. The rules say it is merit come seniority. So let's say merit. So, all right, my lord, so someone says, very well, it's merit, so the entire cadre comes into the picture, so there's no discrepancy, no discrimination also. Two levels of discrimination. Firstly, to be eligible for selection grade, you have to be 5 years as district judge entry level, which a person of higher age will be ill, will not in a position to afford that. Secondly, there is a zone of consideration. So if you are opening up the field to everyone is all right, but you are saying merit comes seniority, but zone of consideration 3:1. So if it is 3:1, then for one post only 3 officers and normally the senior most will be seen. And your lordship saw the West Bengal rule which my learned friend Mr. Jaydeep Gupta cited. The criteria to enter into the zone is fairly minimal, if I may so. One, you should not get E or F, etc. That is not merit, that's mostly suitability for you to reach that level. Either your lordships are opening up the entire cadre for everyone to be considered on merit for selection grade and my lord, the super time scale. Otherwise, zone of consideration will again restrict everything back. Just have a look at one, my lord, rules that I'll cite. Most high courts follow that. Just see the Assam rules. Most high courts have this. It's the beginning of my written submission of the, which volume is this? 4A, page 81. Now, please come to volume 4A.
Volume 4.
Volume 4A, my lord. I'm just citing one. Most of the high courts have the following, my lord, rules. These are the Assam Judicial Service rules. They start, my lord, at
Page 33.
33. But, my lord, I'm not troubling your lordship with that. Please come straight away to, my lord, page 80, Schedule E. 4A.
You are referring to page?
My lord, I was at page 80, Schedule E, which is titled, my lord, General Criteria for Promotion. And, my lord, as I said, virtually all rules follow this pattern, maybe a little bit here and there, but the pattern is the same. So, my lord, the general criteria for promotion, if your lordship has it at page 80, is A. Considering the number of vacancies to be filled up, assessment committee shall assess the judgments ACRs of the officers who are within the zone of consideration, ratio being 1:3. Suitability and overall performance of officers, including disposal of cases, and the remarks of the concerned portfolio judge shall be considered. In case any departmental proceeding or inquiry is pending against an officer, his promotion may be considered and the decision be kept in a sealed cover to be opened on conclusion of the departmental proceeding. D. Officers against whom there is adverse entry regarding their character, integrity will be eligible for promotion provided the required benchmark has been obtained subsequent to the adverse entry. Now, my lord, if your lordship would just turn to the next page. And here, my lord, we are concerned with this subheading from district judge to selection grade district judge, which is, my lord, at the bottom of page 81. So there are 3 criteria. One is merit and suitability. Second, minimum 4 good out of last 5 ACRs, or officer must have 2 good and 1 very good ACRs in the last 5 years. And then, my lord, from selection grade district judge to super time scale district judge, merit comes suitability. Officer must have 3 good and 1 very good grading during last 5 years, or officer must have 2 good and 1 outstanding grading during last 5 years. So, my lord, first of all, there is a time period that for which you need these gradings. Secondly, although it says merit comes suitability, but you have restricted it to 1:3. So, my lord, in a sense, what you are giving, what is sought to be given is pure merit, is taken away with the zone of consideration, because only 3 officers per vacancy are being considered. So, where is the question of the merit across the cadre being considered? My lord, with great respect, my lord, the question I asked.
How with this criteria, Mr. Bhatnagar? How can within a cadre?
Yes.
Again, that most quoted expression. How can we create an artificial parity or disparity on the basis of birthmark?
No, we are not.
They are amalgamated in cadre at the entry point, and
Yes.
seniority point, whether based upon roster or continuous length, whatever may be.
My lord,
Once the seniority list is determined, then how can you further classify them?
I'm saying don't classify. I'm saying that don't reduce it to 1:3. By reducing it to 1:3, you are taking people out of the zone, is what I'm saying. Suppose the criteria is merit.
Selection grade or super time skill can't be granted to the entire cadre.
No, it can't be.
So basically, a financial incentive
Incentive.
on seniority,
Yes.
performance, both.
Why not?
That's why merit comes seniority.
Yes.
It's not something time scale that you have.
It is not. It is not like the civil judge cadre where it is time scale. But what this does in effect is this now excludes people who come in at an older age and therefore either they retire earlier or they are lower down in the. So it adds to the exclusion of people is what I'm saying. If it is pure merit, fine, no problem. That's one way of looking at it. But this is an exclusionary principle.
There is a rule which the interplay between the rule is like this, that it excludes a particular class of person, then understandable. But this is a simple incidence of service.
No, it is an incident. Merit comes seniority is an incident of service. But having said merit comes seniority, which effectively means merit, seniority only if merit is equal, then you make it 1:3. So the age factor, so a person who's older, etc., who comes in later or has later into the cadre or lower, doesn't come into the zone. That's the problem. That's my second submission, therefore, is only based on the zone of consideration. My second suggestion to your Lordship. Lord, the third argument is, my Lord, with respect to the argument, that was made about this being in the nature of a reservation and not being permitted. Mr. Bhushan had argued that point. For that, I only want to cite one para of one judgment before your Lordship, which is, my Lord, at page 43, page 40 of my written submissions. This is not a 5-judge bench, it's a 2-judge bench. But the question here, my Lord, is exactly this.
Page 40 of your.
My Lord, page 40 is a judgment of my submissions, my Lord. There's a judgment called Kuldeep Kumar Gupta, which your Lordships have.
Yes.
My Lord, please turn over the page to 41. There is a question 2. Providing a quota in the promotional cadre, whether can be said to be reservation within the meaning of 16(4), and as such can it be held to be violative of 16(4) of the Constitution? And the answer which was given by your Lordships is at page 43. Just one para I wanted to place. I commend, my Lord, this view with great respect to your Lordship. So far as the second, top of 43, so far as the second question is concerned, we are unable to persuade ourselves to agree with the submissions of Mr. Subramaniam that providing a quota tantamounts to reservation. Article 16 deals with equality of opportunity in matters of public employment, and 16(4) enables the state from making any provision for reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. This court in Indra Sahni's case has held that no such reservation is permissible in the promotional posts, and to get over the said decision, 16(4)(a) has been inserted by the Constitution. But we fail to understand as to how providing a quota for a specified category of personnel in the promotional posts can be held to be reservation within the ambit of 16(4). Providing a quota is not new in service jurisprudence, and whenever the feeder category itself consists of different category of persons, and when they are considered for promotion, the employer fixes a quota for each category so that the promotional cadre would be equibalanced, and at the same time, each category of persons in feeder category would get the opportunity of being considered for promotion. This is also, in a sense, the larger interest of administration, when it is the employer who is best suited to decide the percentage of posts in the promotional cadre, which can be earmarked for different category of persons. In other words, this provision actually effectuates the constitutional mandate engrafted in 16(1), as it would offer equality of opportunities in matters relating to employment, and it would not be the monopoly of a specified category of persons in the feeder category to get promotion. We therefore do not find any infraction of the constitutional provision engrafted in 16(4) while providing a quota in the promotional cadre, as in our view, it does not tantamount to reservation. In fact, my Lord, in the 2002 judgment, your Lordships have provided a 50% promotional quota to, my Lord, judges from the civil judges junior division. That's also, my Lord, there. That's what your Lordships have already done, which everyone has accepted. Lastly, I'll come to the Nath point, which was taken. Now, my Lord, there, the proposition I'm placing before your Lordships is this. When, my Lord, two categories are integrated into one class, they cannot be differentiated on the ground of their birthmark being lost. But this is not a classification based on birthmark. This classification I submit to your lordships, if your lordships accept it, would be in the nature of improving efficiency of administration. In the interest of improving judicial administration, which your lordships in KV Rajneesh, the 5-judge bench which my lord referred to, have said already that judicial experience far exceeds advocate's experience. So, my lord, in my respectful submission, this does not fall foul of the Trilokinath principle at all. Your lordships are not differentiating on the basis of birthmark. But this is
However, here the upgradation is on the basis of experience also. That's experience as judicial experience as a district judge.
Yes.
5 years. So in this situation, how do you add on the additional experience which is already merged into the common cadre?
because that experience only a civil judge, because the vast experience of 15, 20 years, 10 years, 15 years that they have is only limited, is only given to civil judges who come through that route. A district judge does not have that experience, a direct recruited district judge. So either we say that does not count at all. If it does not count at all, then of course the argument cannot be accepted.
Does it have a rational nexus when the role performed is one of a district judge, which is of a much superior judicial role than that of a civil judge junior?
Correct. But even while performing that superior judicial role, the fact that you performed a judicial role is not, in my respectful submission, written off, number one. Number two, what is also not written off is the fact, my lord, that the other person has come as an advocate or perhaps as a civil judge for a few years, but here he's continuously for 15, 20 years been a civil judge. Or, my lord, in the alternative, let's put it this way. Then, my lord, what the Justice Shetty Commission is saying is that give them some weightage for experience.
Another consideration.
That's another consideration.
Entry point.
At the entry point.
Does not fall foul of subclassification in a card.
I'm only giving your lordship the alternative to what I'm saying because I put that also as part of my submissions. That my lord, is also there. The fact that 50% of the cadre, which is the promotional cadre, has that experience which Justice Shetty felt in 2002 to be given. Now, my lord, with great respect, the 2002 judgment of your lordships has rejected it, but there's no reason at all. My lord, there's one line in that judgment.
Relying on Sabarwa.
My lord, it only says one line. My lord, may I just show that line? Show me that 2002. My lord, I have with my written submissions set out in some detail the Justice Shetty Commission recommendations for your lordship's consideration.
That's your third suggestion.
The third submission, to which, my lord, the way the 2002 judgment has said, of course, your lordships are entitled to say that, but my lord, there's no reasoning given at all. It says only, just show me that paragraph. My lord, I'll just read that paragraph. My lord, in fact, this is it, paragraph at page 8 of my written submission is set out there. Para 30, my lord, at page 8, we disapprove the recommendation of giving any weightage to the members of the subordinate judicial service in their promotion to the higher judicial service in determining seniority vis-a-vis direct recruits and promotees. Roster system will ensure fair play to all while improving efficiency in the service. So that aspect has not been gone into, which I have again put before your lordships to please consider now, because this is an opportunity. In Rajneesh's case, for instance, your lordships accepted several of the Justice Shetty Commission's recommendations made in 1999. I'm requesting your lordships to look at this and see whether this could be something that can be gone into. Now, these are my 4 or 5 points.
Thank you.
सर आप इधर आ जाओ. But Mr. Devri wants to just add a little bit.
It's not, but this 5 minutes only if not.
Says with regard to the first suggestion, as far as the Micah's first suggestion is, he's put it as 1:1, but taking in account the fact that there are 3 categories, your lordships. The division in the roster, your lordships, has to be 75, 25, 25.
Then what is the incentive for the direct, if we provide 25 for them? Why would they give that service and come directly?
Your lordships, as far as LDCs are concerned.
For LCD also 25.
Your lordships, I'm talking about LDCs only. As far as LDCs are concerned, your lordships, our roster points cannot be clubbed with either promotees or the direct recruit. It has to be a separate roster point, Your Lordship.
How can there be a separate roster point?
It is already a separate roster point.
No,
As
for
per
a
the-
Gota Gota, rightly, first two will go to the promotees, the third will go to the LC, and fourth will go to a direct.
Yes, Your Lordships, that's what I'm saying, that even in terms of weightage, etc., when that is calculated, Your Lordships, the same benefit should flow to all of us. That is what I'm saying, that as far as LCD is concerned, Your Lordships, it being a category cannot be deprived of the benefit which it is getting otherwise as well. That's
You are
what I'm
already
saying.
getting a jump over the others. So,
Your
this is
Lordships,
a
in
right
bunching,
separate-
come down. The problem that we are facing on ground, Your Lordships, in bunching, we are coming down. That is the problem that we are facing. Whereas because of the merit, Your Lordships, we must be placed higher. That is the ground reality that is happening.
No, this is just 2 minutes I would like to say. The rest is, I will follow what my friends have said. Lord, my submission was to assist to Lordships that the rota system, which has been borrowed from Sabharwal's case, fairly doesn't apply, in fact, because it's a case of one selection and this is the case of 3 selections. So unless we follow the roster system or the selection process as laid down in Malik Mazhar Sultan's case, it would not be possible to apply the roster system at all. So if Malik Mazhar is sought to be followed meticulously, then perhaps simultaneously appointments can be issued not following the roster system. But the problem that arises if we start applying roster system not annually, but like a current account. That should not be done. Otherwise, we'll be attributing seniority to the people who are appointed in 18, 17 or 16 seniority. That would not be. That is resulting in unfairness and bunching. That's my submission.
Quickly for the Madras High Court, Your Lordship.
Thank you.
Lordship, 30 seconds.
Grateful.
की बेनती रिद कर परगास रिद कर परगास रिद कर परगास रिद कर परगास दास तेरे की बेनती दास तेरे की बेनती रिद कर परगास रिद ਰਿਦਕਾਰ ਪਰਗਾਸ ਰਿਦਕਾਰ ਪਰਗਾਸ ਰਿਦਕਾਰ ਪਰਗਾਸ ਤੁਮਰੀ ਕਿਰਪਾ ਤੇ ਪਾਰ ਬ੍ਰਹਮ ਤੁਮਰੀ ਕਿਰਪਾ ਤੇ ਪਾਰ ਬ੍ਰਹਮ ਦੋਖਨ ਕੋ ਨਾਸ ਦੋਖਨ ਕੋ ਨਾਸ ਦਾਸ ਤੇਰੇ ਕੀ ਬੇਨਤੀ ਦਾਸ ਤੇਰੇ ਕੀ ਬੇਨਤੀ ਰਿਦਕਾਰ ਪਰਗਾਸ ਰਿਦਕਾਰ ਪਰਗਾਸ ਚਰਨ ਕਮਲ ਕਾ ਆਸਰਾ
It was almost impossible to make Navdha a 100% natural shampoo. How do you make it lather without using sulfates? And how do you make it conditioning without using silicones? So we started with soaked Rita and Shikakai. To boost the lather, we derived glucosides purely out of coconut. Then